This is really annoying. It's supposed to rain today, but my umbrella just won't fit into my pack. I wish I had a bag that held everything. How can I improve this? It's finally done! My Hold Everything bag is complete! You've been telling me about this project of yours for years. I'll believe it when I see it. Just watch. Wow, that is impressive. But your bag's so ugly, no one's gonna buy it, and it's made out of really flimsy material. Well, I spent all my money designing it, and anyways, I love it. I think everyone's gonna want one of these. You may think that, but I bet I could sell 1,000 times as many bags as you. Well, if you hate it so much, go design your own. Fine, I will. I sent you that bag, but I want it in color 884 and make it out of carbon fiber fabric. I'll take 100,000 units. No way! Hey, I just saw your bag on TV and they say you sold 1 million units? That is correct, my friend. I can't believe you stole my super storage technique. I didn't mean for you to actually go and make your own bags. Well, my bags are sold out in every store. Everyone has one. I haven't even sold one. The story of the Hold Everything bag illustrates the big problem that our first form of intellectual property seeks to solve. On the one hand, our inventor spent time and resources to create the first bag that held everything. And then his friend came along, saw the invention, and just took it. On the other hand, the friend's product turned out to be a huge success. And now everyone has a bag that can hold everything. In this lecture, we'll explore some of the whys of intellectual property law. We'll talk about affirmative justifications for intellectual property rights, the limits of those justifications, and other considerations that shape the scope of intellectual property rights. The question of why we have intellectual property rights is often referred to as intellectual property theory, or justifications for intellectual property rights, or if you want to be really fancy, the normative foundations of intellectual property rights. In this context, normative just means the values that a decision or law is based on. Reasons for having intellectual property rights are important, of course, but the limits on those rights are equally important. As you consider the theories that I'm about to present, I'd also like you to think how far those theories can be stretched, as well as other values or considerations that are important to think about. Justifications for intellectual property rights in inventions, such as our Hold Everything bag, typically draw on theories articulated in two strands of political philosophy. For the first strand, let's turn to 17th century British philosopher John Locke. Locke's writings draw heavily on rationality and logic, often seeking to extrapolate from first principles. In his second treatise of government, Locke argues that valid government derives from the people. One particularly famous section offers a justification for private property rights. Though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided, and left it in, he hath mixed his labor with, and joined to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature hath placed it in, it hath by this labor something annexed to it, that excludes the common right of other men. For this labor, being the unquestionable property of the laborer, no man but he can have a right to what that is once joined to, at least where there is good enough and as good left in common for others. In this passage, Locke offers the idea that each person has a natural property in themselves, and thus the labor of their body. When that person mixes their own labor with something that's part of the commons and available to all, that person now has property in that which they've taken from the commons, provided that there's enough and as good left in common for others. Locke uses the example of gathering apples from a tree in the commons. When someone uses their labor to gather the apples belong to them, as long as there remains enough good apples for others. Let's apply this labor theory to our opening sketch, thinking about whether it provides a justification for giving rights in something to the inventor. In our opening story, the inventor spent their own time working on creating the hold everything bag. They put a lot of intellectual effort into coming up with a bag that could hold everything. They mixed knowledge of pre-existing bags with their own ideas, combining them together. In the Lockean sense, by mixing the pre-existing commons that everyone had access to with their intellectual labor, the inventor came to develop a right in the hold everything bag. Others can still make pre-existing bags, so the Lockean proviso that there remain enough and as good left in common for others seems to hold. This reasoning seems sound on its face, but let's dig deeper. Are there any problems or challenges with labor theory as a justification for intellectual property? For one thing, it seems to work okay when someone else is copying the work of the original inventor. But what if the second inventor comes up with the same invention on their own? Wouldn't labor theory suggest giving them both rights over the invention? Are those rights good against each other? Second, it's difficult to measure the precise amount of labor invested in creating an invention. Maybe someone hears about the idea of a hold everything bag, but not how it works, and then figures out how to make it on their own. Does labor theory help answer who gets what rights? Labor theory also often falters given the collaborative nature of innovation. Inventions often involve contributions from lots of sources and people, and each invention builds on the work of others. Do Alexander Graham Bell's heirs get to claim rights in every smartphone made today? Or stepping into the realm of creative expression for a moment, do William Shakespeare's heirs get to claim the rights to West Side Story based on Romeo and Juliet? Ultimately, labor theory doesn't provide much guidance for a lot of questions that come up in the real world, such as the scope of rights or how long they should last. For the second classic justification for intellectual property rights, let's turn to Jeremy Bentham, another British philosopher who lived about 100 years after Locke. Bentham's central theory is described as utilitarianism. The core idea of utilitarianism is to maximize the well-being of all, and government and law should operate to achieve that end by considering all the consequences.
With respect to a great number of inventions in the arts, an exclusive privilege is absolutely necessary in order that what is sown may be reaped. He who has no hope that he shall reap will not take the trouble to sow. But that which one man has invented, all the world can imitate. Without the assistance of the laws, the inventor would almost always be driven out of the market by his rival, who, finding himself without any expense in possession of a discovery which has cost the inventor much time and expense, would be able to deprive him of all his deserved advantages by selling at a lower price. An exclusive privilege is of all the rewards best proportioned, the most natural, and the least burdensome. It produces infinite effect, and it costs nothing. Grant me 15 years, says the inventor, that I may reap the fruit of my labors. After this term it shall be enjoyed by all the world. Does the sovereign say, no, you shall not have it? What will happen? It will be enjoyed by no one, neither for 15 years nor afterwards.
In this excerpt, Bentham is saying that we as a society want inventions. But there's a big problem. That which one man has invented, all the world can imitate. As a result, the inventor would almost always be driven out of the market by his rival, who, finding himself without any expense, in possession of a discovery which has cost the inventor much time and expense, would be able to deprive him of all his deserved advantages by selling at a lower price. Think back to the story of the hold everything bag. To create this bag, our inventor, let's call him Joe, needed to spend a lot of time working on it. He needed to invest resources in creating the mechanism to hold everything. It took a lot of time and money to create that first bag. Now, once Joe's designed the new bag, he can make copies of it. He knows how it works, how it's put together, the best type of materials to use. He's got the basic idea all set. Of course, every time Joe makes a new bag, it's going to cost resources as well. It's going to take cloth, it's going to take leather, it's going to take all the components for the hyperdimensional portal generator. The result is that our inventor's costs as a creator are both the cost to design and build the first bag, as well as the cost to produce each additional bag. Along comes Joe's friend, who we'll call the Richmeister. The Richmeister sees Joe's new bag and he says, "Wow, I've got a prototype right here. I can just copy it. I don't need to spend the resources to design this amazing bag. My costs are only going to be the cost of producing each additional bag in the future." So as a result, the Richmeister's costs are just the cost of making copies. Now you can see the imbalance here. Inventor Joe has expended substantially more resources in inventing the Hold Everything bag than the Richmeister has. And so who's going to win in the marketplace? The Richmeister is going to be able to charge a lower price than Inventor Joe because his costs are going to be lower. The Richmeister is going to make a profit and Inventor Joe is going to get nothing. Joe's going to say, "I shouldn't have quit my day job," and is going to go back to doing something other than creating amazing new bags. Society is going to be worse off because as a result, we're not going to get these new bags. We're just going to get copies of things that we've already have. That's the big problem that systems such as patent and copyright law try to address. But utilitarianism doesn't specify how we might solve the big problem. What ways can you think of to ensure that our inventor keeps on inventing bags? Go on, write them down. I'll wait. There turn out to be lots of ways that the big problem can be solved. For one thing, creators might create for reasons other than money. Maybe Joe just wants to create bags for fun, or for prestige, recognition, or the common good. Another mitigating factor is that copying may not be costless. It may not be as easy to just make a copy of a bag as to use a photocopier. There can also be first mover advantages. This is the idea that the first entrant into the market often has a substantial advantage over competitors who follow on later. Everyone else has to race just to catch up. First mover advantages can be even stronger when there are market characteristics that make it difficult for others to enter the market. The creators might also have unique knowledge that's not obvious from the product they're selling that can offer an advantage. Joe knows all the stuff that he needs to assemble the hyperdimensional portal generator without it blowing up. The Richmeister is going to have to figure that out. There may also be societal norms against copying. For example, in school, you have rules against copying other people's work. Sometimes those rules are formalized in policy. Other times, they're just social norms against duplication. You see this in areas like stand-up comedy, where comedians are socially penalized for copying each other's material. If such norms exist in a particular area, they may reduce copying as well. The government can also try to solve the big problem itself. For example, it might fund research directly, something that can produce amazing results, but costs a lot of money. Or the government could award prizes, also a solution, but also one that costs money. Or it could give tax incentives for research and development, which are basically another way of financing the research. The difficulty with all these solutions is that every form of governmental intervention has costs. This is just a basic principle. Anytime the government acts, it's going to have costs associated with that act. Direct funding, prizes, tax incentives, they all cost money. And the government is kind of running at a deficit. It doesn't have as much money as it would like to spend. And so while it uses all these mechanisms, its ability to do so is naturally constrained. Even when the government isn't running at a deficit, it still has a budget and it still needs to allocate its resources in a way that's most socially advantageous. And just funding innovation isn't its only priority. But there's another way to address the big problem. When we think about the primary basis for federal law in the United States, we generally first turn to the Constitution. The Constitution provides the federal government, specifically Congress, with certain powers. Article 1, Section 8, Clause 8 of the Constitution states that the Congress shall have power to, among other things, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Clause 8 sounds like straightforward utilitarianism. The rights it authorizes are framed in terms that Bentham would probably relate to. Clause 8 authorizes the creation of incentives to achieve a particular societal outcome, in this case, the progress of science and the useful arts. In contrast, European systems are based more on a combination of utilitarianism, labor theory, and the concept of personhood, a theory that we'll talk about later on in the course. Given that U.S. intellectual property law is primarily rooted in utilitarian conceptions, the key question then becomes what are the ends and what are the means for getting to those ends? In other words, what goals are we trying to achieve through the law, and how are we going to achieve those goals? Let's start with the ends. What kind of goal is intellectual property law trying to achieve? Think back to Article 1, Section 8, Clause 8. It's about promoting the progress of science and the useful arts. Now, at the time the Constitution was written, the word science had a different meaning than you might think of today. It had a broad meaning, encompassing systems of knowledge derived from reason and observation. Science, at the time the Constitution was written, encompassed subjects as wide-ranging as philosophy, ethics, mathematics, and the arts. In comparison, useful arts encompass skills or practices with a practical application, what we can think of today as technology. Broadly stated then, Clause 8 on its face seeks to encourage the expansion of knowledge, thought, and understanding, and the development of technology. This is something that both a young fledgling nation and a well-established one can benefit from. So the progress of science and the useful arts are our ends. What then are the means offered by the IP clause? The answer is a system of laws to optimize the production of ideas and content by creating a system of property and property-like rights. These rights mean that creators can stop others from using or copying their ideas. Because the creators are the only ones who can make and sell their creations, they can charge more than a purely competitive marketplace might otherwise allow. Or the creators might license their rights to others who will make and sell the creations. Of course, there are many details to be worked out, but the core concept is simple. Exclusive rights in an invention are a powerful incentive for inventors to invent, because the inventor knows that they'll have rights in what they create. In Bentham's words, the inventor can reap what they've sown. Exclusive rights sound great, but are they always? As I mentioned earlier, every form of governmental intervention has costs. So here, what are the costs with exclusive rights in things like inventions? One big consideration is that we don't want to pay for things that we already have, or that we're going to get anyways. Remember, once the law grants an exclusive right to something, that means that we, the public, are going to have to pay for it rather than use it for free. Take the idea of using salt to season our food, for example. We already have that. What would happen if today we gave someone the exclusive right to the idea of using salt to season our food? Anyone who wants to use salt to season their food would have to pay the owner of that right before they could use salt. That person would grow very rich, and the rest of us would be pretty unhappy, and either quite a bit poorer or stuck with very bland food. So a key part of the exclusive rights mechanism is making sure that we're not giving rights to ideas that we already have, or which are going to create new problems that might be worse than the underproduction of ideas or creative expression. Another cost is that of administering the system. If you remember from property law, the government has a system for administering real property rights, a registration-type system where rights to property are registered with state governments. This mechanism provides notice and clarity for people when they're trying to figure out who has rights in a given parcel of land. But that system costs money. You need people to maintain it, you need people to keep the records, you need people to verify the records. When someone buys a piece of real property, they have to record their transaction with the clerk's office so that there's a record of it. That takes time and money as well. The same types of costs can apply in the context of intellectual property rights. If the government sets up a system to record intellectual property rights, it's going to cost money. And perhaps the government wants to go beyond simply a registration system and actually examine whether the person who's claiming these rights is entitled to them. That's going to require people and time and money to do. We also have transaction costs. For example, if you're a new business and you're trying to figure out whether or not you're going to infringe someone else's patent when you sell your bags, that's going to take time and resources. Figuring out who has the rights, what the rights look like, and then transacting over those rights all costs for the system. Another cost associated with intellectual property rights are the effects on downstream creators. Every exclusive right we give out today reduces the incentive for future creators who are going to build on the work of the now creator. If everyone has to pay the Wright brothers estate whenever they create a new type of airplane, then it's going to reduce the return for creating those new airplanes. We call this the upstream-downstream problem. Yet another cost is the potential for disproportionate effects, particularly on those who are less able to take advantage of legal rights. Intellectual property rights can be costly to enforce, and often a wealthy, powerful entity is better able to use these legal mechanisms than one who's not. Although often touted as a mechanism for disruption of entrenched economic power, intellectual property rights can also further advantage dominant actors in a market or society. As we move through patent law, we'll talk more about these costs. We'll also talk about ways in which the law balances the benefits and costs from exclusive rights. For example, the upstream-downstream problem is often dealt with by giving rights for limited periods of time, so that at a certain point the legal right in the creative intangible expires, and everybody can now make use of it without having to spend resources to determine the scope of the right and transact with the owner of the right. In the end, there are real costs associated with a system of legal rights in creative intangibles. This leads us to the ultimate question for intellectual property. Are legal rights in creative intangibles justified? From a utilitarian perspective, do the positive consequences outweigh the negative? Unfortunately, I can't give you a simple answer to this question. There isn't one. It's a complex problem that depends on the type of intellectual property rights, the subject matter, the context, and more. But whether legal rights in a particular form of creative intangible are justified, and whether the limits on those rights are appropriate, is an important question that you should keep thinking about as we dive into some of the core laws in patent and copyright. Today I'm here with Jeremy Bentham, the creator of the theory of utilitarianism. Now, Mr. Bentham is no longer with us, having died several hundred years ago, but his theory is still with us and something that we study in this course.